Good morning, good afternoon, good evening from wherever you're joining us from today. A very warm welcome, ladies and gentlemen. My name is Elvis Mogesa Ongiri, and welcome to Kabarak University Press's first webinar on reflecting the first 25 years of the African Union Constitutive Act. This webinar, as one of two on this overall theme, will dwell on the drafting history, the legal philosophy, and the broad objects of the AU Constitutive Act. It is a part of a two-series webinar, and next week, 14th August 2025, we will have a second webinar that will focus on the successes, the challenges, and the future prospects and AU reforms. The registration link for this second webinar will be shared in the chat function. We are honored to have a distinguished panel today to lead our discussions, whom I will introduce shortly. But before that, we at Kabarak University Press are privileged to host the International Law Month at Kabarak 2025. This particular webinar, alongside next week's webinar, is a collaboration with Pan-African Lawyers Union. At Kabarak University Press, we believe that a Global South academic publisher must be a proactive enabler of the scholar conversations and reflections that answer to the intellectual questions of our time. It is in this spirit that we have convened this webinar today. The International Law Month at Kabarak is an annual month-long series of activities aimed at highlighting the international law questions relevant to the Global South today. This year is the first year of this intellectual focus month. It entails a series of webinars, which we have been announcing and already held, and the launch of a blog on international law named in honor of Dr. Bonaya Godana. Dr. Godana's legacy as Africa's first international freshwater law scholar was the object of a discussion in a previous webinar, the 18th of July 2025, that featured a distinguished panel of His Excellency Judge Abdulkawi Yusuf, Professor Laurence Poisson de Chorzon, Professor Phoebe Okoa, and the family of the late Dr. Godana. Our first webinar was also on international space law and space debris. All of these webinars are available at our YouTube page at Kabarak University Press. Lastly, Kabarak University Press is also happy to remind you that Kenya, as a candidate for the elections to the International Court of Justice of November 2026, a close friend and a supporter of Kabarak University Press, Professor Phoebe Okoa. We are honored to support and contribute to Professor Okoa's candidacy, and you can look at our social media handles for this. The object of discussion today, reflecting on 25 years of the AU Constitutive Act, is also the issue theme of our flagship student-led journal, the Kabarak Law Review, in which I serve as the editor-in-chief. We hope to publish a transcript of this webinar, and we also welcome short reflections that stem from the conversations we are going to have today. The submission guidelines are available at the Kabarak Law Review website. So to start us off with the opening remarks, I welcome Mr. Humphrey Sipala, the editor-in-chief of the Kabarak University. Welcome.
Thank you so much, Elvis, for your warm introduction. My name is Humphrey Sipala, and I am honored to welcome our distinguished panel and our audience to this conversation, the first of a series that we are partnering with the Pan-African Lawyers Union to reflect as Africans on the premier treaty, the premier continental body for us, but also for international law scholars, our premier treaty system. Mokhtar Ould Daddah, the first president of Mauritania, in his memoirs, which instructively is titled La Mauritanie contre le vent et le marais, which is really Mauritania created against all odds. He has some pages where he reflects on the early 60s and the struggles to create a premier continental body for Africa. What is not so widely spoken of was the parallel establishment of the Africa-Malagasy Union, which became the Africa-Malagasy Common Organization. And so in the early 60s, in 63, 64, 65, it was not obvious that the OAU would be the premier continental body and that the OAU Charter would be the mother of a premier treaty system. And so just like La Mauritanie was created against all odds, or to transliterate between the winds and the tides, so was the Organization of African Unity. Our panel here today is uniquely placed to help us understand how the successor of the original treaty system and the original continental body, the Organization of African Unity, and its charter, transforms through the Abuja Treaty of 91 into the Constitutive Act of the African Union as a continental body, as a bearer of the vision of what Africa should be, could be, and as the center of a treaty system. That sense of struggle, of debate of ideas, of the political context, the political history, is critical in us assessing where we have been, what we have succeeded in, what we failed, what we hope to succeed, and the future. And so I'm very honored to be welcoming our distinguished panel, and I look forward to listening. Thank you so much.
Thank you so much, Mwalimu. So to start us off, we'll have Professor Hajer. Professor Hajer is a leading expert in public international law. She's also the legal counsel to the African Union and had previously served as a member of the African Union Commission on International Law from 2015 to 2023, becoming the Commission's first female president. She's also a full professor of public international law at Carthage University in Tunis, and she has served as visiting professor in several countries such as France, Italy, Lebanon, Canada, and Cameroon. She has published widely on AU law, and her 2019 book, Law, Practice and Institutional Reform of the African Union, published in French, is an important addition to this oeuvre of African Union law, or the public law of Africa. Please welcome Prof. Hajer.
Thank you so much for introducing me. Thank you for the organizers. Thank you for these reflections. We need it. 25 years later, you said the Constitutive Act is original. I agree. And in my remarks, I will highlight these ideals. This is our Bible, the Constitutive Act. It is as the Charter of United Nations for the United Nations. However, in my remarks, I will also address the challenges and the gap between these ideals, these principles within the Constitutive Act, and between what we need now. And maybe we can finish with some recommendation. And I'm sure that the second round of the panel will be also very interesting, because 25 years after the Constitutive Act, we still need to analyze, we still need to ask questions, we still need to challenge ourselves and to prepare the next generation. I believe that even if this generation didn't succeed today, they will at least inspire the future generation. And this is your work, you professors, students, lawyers, the intelligentsia of Africa. So this is really very interesting brainstorming around the Constitutive Act. So distinguished moderator, honorable panelists, colleagues, students of international law, good morning, good afternoon, depends where you are. I'm sorry for the noise. I'm just jumping from one point to another. I'm at the airport. So sorry, because I didn't have any other choice, but at least I wanted really to share my opinion on 25 years after the Constitutive Act, and I wanted to hear about your respective opinions and to ask questions and to see together how we can go over these challenges and give good reflections and good recommendations for the future. So I'm trying also to put on my LinkedIn and on my links all what you are doing on your university, because I think you are one of the best editors speaking about Pan-Africanism and international law within the African Union. So thank you so much for all your efforts, and you can always rely on me as a professor, but also as the legal counsel of the African Union. It is really a honor to join you today at this first webinar of Kabarak's International Law Month, reflecting on a legal instrument that lies, as I said, at the very heart of the Africa's collective identity and aspirations. This is our Constitutive Act of the African Union. It's our Bible, as I said. So I wish to thank Kabarak University, Kabarak Law Review, for creating this essential discussion, and it comes at a time when the continent is not only assessing its progress, but it is also renewing its legal and its institutional architecture for the future. And as the legal counsel of the African Union, I have the honor and the privilege and the responsibility of working daily with this living legal framework. The Constitutive Act for the Legal Counsel of AU, it's really the number one in the hierarchy of the instruments. It is always on my desk and it is always in my luggage. I'm all the time referring to the Constitutive Act as the legal counsel of the AU. And also as international law scholar, I see in this Constitutive Act not merely a regional treaty, but it is a bold and a transformative legal manifesto, one that advances a distinctly African vision for the evolution of international law itself. So the birth, and maybe the other panelists will go through the history, I will just be very brief on the birth of a new normative order, according to me. Because the adoption of Constitutive Act in Lome in 2000, 25 years ago, signified more than a rebranding of the Organization of African Unity. It was, in a sense, a rupture with the past, a legal emancipation from the rigid, non-interventionist paradigm of the post-colonial era. From a legal positivist perspective, it will mark a pragmatic shift in the architecture of the African regionalism. For example, if I go to the Article 4H within the principles of the Constitutive Act, you can find the principle of non-indifference. It is not the principle of the non-interference. It is the principle of non-indifference regarding the international crimes. And this Article 4H is rare. It does constitute a rare normative evolution. It is unique in international law, in positive international law. It empowers the Union to intervene without invitation in a member state in cases of war crime, genocide, and crimes against humanity. And this formulation departs from the classical interpretation of sovereignty under the Article 2, paragraph 7 of the United Nations Charter. And it does give rise to new understandings of the limits of domestic jurisdiction when it is confronted with the mass atrocities. And this provision, as you know, has been praised in legal scholarship as an early articulation of what would later be accepted as the responsibility to protect. However, it is also grounded in Africa's own jurisprudence heritage, including our African Charter on Human and People's Rights and the historical experience of post-colonial armed conflicts. And in this regard, the Constitutive Act not only aligns with, but it does contribute to the progressive development of customary international law. After that, I can just also highlight several provisions of the Constitutive Act that render this instrument a sui generis legal text. Sui generis legal text, again, I need to underline the innovation and the rare transformation of international law within African Union with really very courageous and interesting frameworks and concepts among the foundational documents of regional organizations. When even you compare to the inter-American and to the European legal framework, I think we are in advance and we can be proud of this Constitutive Act when it is about the innovation. For example, the issue of democratic legitimacy as a legal requirement, and I have highlighted the Article 30 that codifies the illegitimacy of governments that come to power through unconstitutional means. And this is not a political declaration, but it is a legally binding provision operationalized through the decisions of suspension, sanctions, and in some instances, referral to the Peace and Security Council. It marks a departure from the permissiveness of earlier international practice, and it does reinforce the principle that legitimacy derives not merely from effective control, but from constitutional and democratic process. So, under unconstitutional changement of government, the member states of AU are suspended. This is the Article 30. It's about sanctions, and the sanctions are current, and they are articulated in a way that these different states, when they reach again the democracy, they will come back. They're well welcomed to the African Union arena. So this innovation has not been free from contradiction, and the inconsistent application of Article 30, influenced by geopolitical alliances, varying political will, and institutional constraints, threatens to erode its normative force, and the proliferation of unconstitutional chains of government in the recent years in Africa, including the coup d'etat and powers grabs under the guise of constitutional reform, exposes the fragility of our enforcement architecture. Also, we have another issue, which is the institutional equality and the anti-hegemony. In the African Union, it is perhaps the only continental organization that constitutionally enshrines the equality of all its member states without any privilege to any of these states with any veto powers or permanent seats, like it is the case of Security Council of the United Nations. We do not have veto right. We have equal members. We do not have permanent and non-permanent seats in our Peace and Security Council. And this does reflect the Pan-African aspiration to a horizontal, it is not hierarchical, situation and order in international relations. And this is also something that is very important within our framework. However, this egalitarian design also places considerable pressure on consensus building processes, often resulting in protracted negotiation and diluted decision making. When I go now to the integration and to the integrated mandate, our Constitutive Act blends human rights, peace and security, economic development, and social justice into a single legal instrument. We have all these issues together, and these are also the pillars of Agenda 2063 and what we are the aspiration of an Africa that is united and strong and developed and with one voice. And this contrasts with the segment mandates seen in other regions, and it does affirm the indivisibility of rights and the interdependence of policy domains as an approach that reflects both African jurisprudence and the holistic philosophy embedded in instruments such as the African Charter on Human and People's Rights. We have also this constitutional hierarchy because our act functions not only as a treaty, but as a constitutional order. It establishes foundational principles, institutional competences, and binding values. And in this setting, apart from mere intergovernmental charters, its supremacy over other AU instruments is recognized in AU practice and in AU jurisprudence. And we have with us Judge Ben Kioko, who is also the institutional memory of the AU, and also he continues as Honorable Judge of the African Court on Human and People's Rights. And I think also for the court, the Constitutive Act is the Bible. After comes the African Charter on Human and People's Rights and all the other instruments within the human rights issues. Ladies and gentlemen, Africa's contribution to the evolution of international law is important. Africa has not merely adopted the norms of global international law, it has refined and redefined them. And the Constitutive Act is part of a larger normative constellation that does include, for example, the Lomé Declaration of 2000, advancing legal accountability for unconstitutional governance. We have also the African Charter on Democracy, Elections and Governance of 2007 that thus provides enforceable standards on democratic norms. We have also the EU Transitional Justice Policy of 2019, which integrates local justice mechanism and community-based reconciliation. We have the Malabo Protocol of 2014 that does establish criminal jurisdiction over international crimes at the regional level. It does include not only the 4 classical international crimes that you know, but it will also include fighting corruption, fighting terrorism, fighting other crimes like environment crimes. And here, Africa is really pioneer, and it is original in this text. We have also the Maputo Protocol on women's rights. We have also the Malabo Protocol, Malabo Convention on the IDPs, the international displaced persons. And this is also rare, and it is unique instrument in the international positive law. And moreover, through the African Union Commission of International Law, the AUCL, I was member of AUCL and had the honor to be the president, the chairperson of AUCL. And AUCL is really giving its capacity and its experience and its advice to codify, to progressively develop international law, international legal order within the African Union, contributing to the universality of international law while preserving legal pluralism. However, again, in all my speech, you can see that I'm picking up the positive issues, but I say all the time, however, in the contradiction, because there is always this gap. There is a lot of gaps and a lot of contradictions between the ideals, the principles, and between the reality and what is done, and the respect of these issues and this legal framework and its implementation. This contribution, I said, faces existential threats, and the crisis of Pan-Africanism, for example, precipitated by shifting global geopolitics and internal democratic decline, has intensified during these last 10 years. The continent, our African continent, grapples with a resurgence of terrorism, transnational crime, violent extremism, displacement of population on an unprecedented scale. And you can see the statistics on the refugees, the number of IDPs in Africa, the number of the people who are migrating within clandestine and illegally to Europe and others. We have a lot of international crime conflicts, both armed conflicts, both international and internal, and the statistics speak from themselves. So this phenomena expose the chasm between the Constitutive Act's normative ambition and often grim reality on the ground. This is the gap I needed to highlight, and this is really realistic. It is not only to criticize, but it is also, again, to see and to brainstorm about what we can do, what the reform spirit, what we can give as a recommendation. And this is also your role in your as editorial team and as a review on international law, on African Union and Africans' perspective, how we can put recommendation and how we can seek the advice of the intellectual how to say our people from Africa, and our experts, our scholars. It's very important really to highlight all these issues with a realistic being ambitious, it's fine, but we also need to be realistic, and we need to highlight the political will that it is not yet there, and we need to encourage this, because we are also responsible of the next generation. We are the one who inspire them. We are the one who inculcate them the Pan-Africanism and all these principles of the Constitutive Act. So to bridge this gap, I'm just finalizing my speech. The implementation of the Constitutive Act must be democratized. This is my idea, to bridge this gap between the ambition, the normative ambition, and the problem on the ground and the reality. I think we need to democratize the Constitutive Act. And I do not know if our people in Africa, at least I come from Tunisia, and I try to do the first and the unique master's degree on African Union law, because as international law professor, I asked my students, do you know Constitutive Act? They said no. Do you have an idea about the African Court on Human and People's Rights? They said no. Do you know what is the capital of Africa? They said no. So because we are far from these, these legal instruments, I decided with Professor Rafa Ben Ashur, who is my professor, and he's actually the judge in African Court on People and African Court on Human Rights and Human and People's Rights, to begin with this idea of a master's degree on African Union law dedicated only to the African Union framework, legal instruments, institutions. And it was a success, and we are proud to have 7 promotion of students who just are really very embedded in the issues of the legal instruments of the African Union. So the youth, for me, civil society, media must become the co-guardians of these principles of the Constitutive Act. You have a responsibility and you have a role. It is not only about our leaders, it is also a shared responsibility, because the future of African integration will depend not only on intergovernmental processes, but on civic constitutionalism and on the reappropriation of the AU's fundamental values by its peoples, we, Africa's people. So legal education, public litigation, participatory policy making are all mechanisms that can breathe life into dormant provisions, because I consider them that they are dormant provisions. They are just black and white. They are not real. And I'm sorry to say that, but I'm really very realistic. I am in the arena, within the arena of African Union, and I observe that there is still not political will to adhere completely to these principles of the Constitutive Act. That's why the African citizens that you are, as envisaged in the preamble of the Constitutive Act, must become the subject and not merely the object of integration. You have a responsibility and you have a role. And the 25th anniversary of the Constitutive Act is not only a historical milestone, but also a moment of reckoning. And the AU must consolidate its legal foundation through reinforcing compliance mechanism of Article 30, operationalization of Malabo Protocol. Malabo Protocol 10 years after we have only one single ratification from Angola. Greater justiciability of African Union law through expanded access to legal resources, and the continued evolution of institutional frameworks that can respond flexibly to complex and transnational crises. But above all, the Constitutive Act must remain a living instrument capable of interpreting Africa's ever-evolving needs while rooted in its foundational principles: unity, solidarity, justice, and dignity. And now I conclude with some reflection that will be inspired from the fundamental vision embedded in the Constitutive Act. And I quote, "We need an integrated, prosperous and peaceful Africa driven by its own citizens and representing a dynamic force in the global arena." So this is not merely a political aspiration. It is a constitutional promise, one that imposes the duties on states and thus empowers institutions and thus affirms the agency of the African people. And in the spirit of legal renewal and civic hope, let's together recommit ourselves to building an AU not just worthy of its name, but true to its normative foundations. Thank you so much, and thank you for your kind attention. And I will continue to be with you online and wish you a fruitful discussion. And I will learn also from the other panelists. Thank you so much.
Thank you so much, Prof. Hajer. I think you have taken us through an expansive discussion of your reflections, and as you put it, the Constitutive Act is both a Bible and a constitution to African peoples, but you also note that there's an existential threat to it, and one of your proposals is that democratizing the Constitutive Act. I'll move on to our next panelist, who's His Excellency Judge Ben Kioko, who's a Kenyan jurist and who has served in the African Court on Human and People's Rights, holding the position of Vice President from September 2016 to 2021. He was first elected as judge in 2012. And before this, he was the long-serving legal counsel of the African Union, including its predecessor, the OAU, for over a decade. He oversaw treaty drafting of at least 25 treaties on different areas in the building of their treaty bodies, and one of them being the object of our discussion today. So welcome, Judge Kioko. Thank you.
Thank you very much, Elvis, for that kind introduction. At the outset, I would like to pay tribute to Kabarak University and all those working at Cabo Press, my friend Humphrey, Elvis, Ms. Nyamu, and your other colleagues, and also to PALU, which is represented by Don Dare. I also recognize my fellow panelists and commend Professor Hajer for the very powerful presentation and the important role she continues to play in the service of the continent. In my presentation, I'll be speaking to a number of issues, including sketching out the fundamental or key differences between the two foundational legal instruments, what motivated the change. I will highlight some aspects of the process and the main issues or challenges, including during the early implementation of the Constitutive Act. I will also share some brief perspectives on the aborted processes for Union government and an African Union Authority from 2005 to 2013. But before I do so, let me just say that I believe all of us know that the OAU Charter was the product of a consensus between two groups. The Casablanca group led by Kwame Nkrumah, which advocated for a politically unified Federation of African States. And on the other hand, the Monrovia group led by Leopold Senghor, which preferred a loose alliance based on gradual economic integration. Evidently, it is the Monrovia group that prevailed in the framing of the OAU Charter. However, the vision then and subsequently has always been that the integration process would ultimately lead to the United States of Africa. Indeed, some African constitutions make provision on giving up sovereignty in favor of continental unity. Unfortunately, every new initiative on African unity, every time a new initiative came up, it came up with its own timelines, with the result that the earlier goalposts were kicked down the road. And I think my presentation will demonstrate that. On the issue of what changed, I think I see three areas where there were major changes. One is on objectives and the core principles. Those changed. And I don't really need to go into what changed in the core principles because I think all of you can read for yourselves to save time. New organs were created, and of all the organs that are set out in Article 5 of the Constitutive Act, all of them had been set out in the Abuja Treaty establishing the African Economic Community, with the exception of the African Union Commission and the Economic, Social, and Cultural Council, which is an organ of civil society engagement. Now, the third area is institutional powers. And again, Professor Hajer has highlighted some aspects of it, including interference in member state to prevent mass atrocities, and also the issue of sanctions. So again, I will not deal a lot on that. The second issue that I'll deal with is why the change from the OAU to the AU. I would argue that a multiplicity of factors influence the decision to transform the OAU to the AU. I will highlight only four. One was the frustration with the slow pace of review of the OAU Charter. By late 1970s, much of Africa had been liberated from colonialism, except for the racist regimes in South Africa and Zimbabwe. In an assembly meeting held in Monrovia, Liberia in July 1979, the assembly decided that the OAU Charter should be reviewed and set up a committee of 14 states to make a detailed study and I quote, to re-examine the provisions of the Charter in the light of the changes and realities in Africa and make specific proposals, end of quote. Interestingly, by May 1982, the committee had completed its work, but for reasons that remain unclear, its work was not formalized and remained in the archives. By early 1990s, the committee work had been overtaken by events, with the completion of the decolonization agenda leading to the elections in South Africa in 1994. And therefore, the work done by the earlier committee had to be redone again. The second reason why for the change is the perceived inability of African countries to speak with one voice, particularly in the international arena. African countries are notorious for departing from agreed African common positions at the international fora. And that is for many reasons, divisions along linguistic, geographical, and other divisive tendencies. Number three, there was frustration, and this was expressed several times by heads of state, with the slow pace of political and socioeconomic integration, and especially the slow implementation of the Abuja Treaty, which was adopted in 1991 and came into force on May 12, 1994. Now, the Abuja Treaty, this is the one for the African Economic Community, envisioned a phased continental integration process in 6 stages of variable duration, spanning 34 years, using the existing and future regional economic communities as building blocks. Those 6 stages would have moved us from a free trade area to a customs union, to a common market with the free movement of people and the rights of residents, to a single domestic market, a Pan-African Economic and Monetary Union with an African Central Bank and a single currency by 2028, meaning 3 years from now, we are supposed to have had a single market, a Pan-African Economic and Monetary Union, and a single currency. In other words, 3 years from now, we should have been like the EU. Number 4, and that is the final reason for the change, according to me, and there are many others, faced with a globalizing world, especially the fall of the Berlin Wall in November 1989, the continent was forced to take stock of these developments and act accordingly. In the AU Summit of 1990, a landmark draft declaration was submitted by the then Secretary General of the OAU, Dr. Salim Mohammed Salim, which basically looked at the fundamental changes taking place in the world with the fall of the Berlin Wall, the shifting East-West alliances, the emergence of the process of globalization with its various opportunities and threats, and more importantly, the process towards European integration. And basically the idea was to say, with all that is happening, what are the implications for Africa? And the declaration outlined the impact of the new reality on Africa, the challenges we faced, and their root causes, and agreed that there was imperative need to look for solutions from within. It underlined the need for finding peaceful and speedy resolution of conflicts, promote democratic governance, popular participation, good governance, human rights, rule of law, eradicate the root causes of the refugee problem, and ensure high standards of accountability and popular-based political processes, including especially women and youth. These conclusions were subsequently amplified in the 1993 OAU Mechanism for Conflict Prevention, Management, and Resolution of Conflicts. And again, there was also an important document called the Cairo Agenda of Action for Relaunching Africa's Economic and Social Development in 1995, which underlined the need to address internal challenges of governance, the root causes of conflicts, respect for human rights, etc., etc. And I would add that the 1994 Rwanda genocide was a loud wake-up call, which the AU had tried but failed to deal with through the Arusha process of negotiations. Then I now move to the SILT declaration and the negotiation, adoption, and early implementation of the Constitutive Act. The main process of the Constitutive Act started at the Oja Summit in 1999. At the Oja Summit, among other things, Colonel Gaddafi submitted a proposal to convene an extraordinary meeting of the Assembly on the issue of the transformation of the OAU, and specifically to discuss ways and means of making the OAU effective so as to keep pace with political and economic developments taking place in the world. And the summit took place then in Sirte, Libya, on 9/9/1999. Accordingly, an extraordinary session was then held, and as usual, at every meeting of the Assembly, documents are prepared by the Secretariat, taken to government experts and ambassadors, and then ministers. However, at the summit level, Colonel Gaddafi submitted 2 alternative proposals directly to the summit, which no one else was aware of, including the ministers. One was for the establishment of the United States of Africa, the USA model, and the other for the Union of African States, the former Soviet Union model. The leaders discussed the Gaddafi proposals, and the predominant opinion was that Africa was not yet ready for a federation or confederation. In the declaration that was adopted, the CETA declaration, the summit, rather than adopting any of those models proposed by Gaddafi, agreed on the establishment of an African Union in conformity with the ultimate objectives of the OAU Charter and the provisions of the Abuja Treaty. And the summit decided and underlined the need to accelerate the process of implementing the Abuja Treaty, shorten the implementation periods of that treaty, ensure the speedy establishment of all the institutions provided for in the Abuja Treaty, such as the Africa Central Bank, the Monetary Union, the African Court of Justice, the Pan-African Parliament, etc. And finally, the strengthening and the consolidation of the regional economic communities. Internally, the Secretary General established interdepartmental task force and a multidisciplinary team of expert consultants with backgrounds in politics, law, economic integration, and international relations were also hired from outside. And they were given 3 weeks to develop the preparatory documents. We at the Secretariat felt that we needed to give them a free hand so that we don't influence whatever they were going to come up with. But of course, we were available to provide whatever documentation or explanations they requested. However, when the team submitted a draft Constitutive Act, they came up with a pyramid type of institutional framework with the AU and the African Economic Community at the bottom of the pyramid and the OAU at the top of the pyramid. In other words, we were now going to retain 3 institutions. Internally, we felt that there would be duplication, certainly, particularly on political issues, but also we felt that this, no doubt, represented a misunderstanding of the CETA declaration. And therefore, a small internal drafting team was set up, which I chaired, and which later reviewed the draft and redrafted the text, and was submitted to 2 consecutive meetings of ambassadors, experts, and parliamentarians, held in Addis Ababa in April 2000 and in May 2000 in Tripoli, Libya, respectively. And thereafter, a ministerial meeting was held also in Tripoli, Libya. They reviewed the drafted Constitutive Act and decided to establish a member states working group to work with the Secretariat to further elaborate on the draft act. The said working group carried out the assignment and submitted the revised draft Constitutive Act to the Council of Ministers in Lome, Togo in July 2000 and thereafter to the Assembly. Now, at that session in Lome, Togo in July 10 to 12 July 2010, the Assembly then formally adopted the Constitutive Act with amendments on 12 July 2000 and urged member states to ratify it as soon as possible. And in fact, it came into force a little less than 1 year on the 26th May 2001, just before the Lusaka Summit of June 2001. At the Lusaka Summit, the Secretary General was mandated to undertake consultations on the modalities and guidelines for the launch of the organs of the Union and to prepare the draft rules of procedure for these organs in consultation with the ambassadors and an ministerial committee. The Assembly also declared a transitional period of 1 year. Now, then we come to Durban, South Africa in 2002, July, where the Assembly held its first inaugural session. And then there was also a public inaugural session at the FNB Stadium in Durban on 9 July 2002. At the Durban Summit, the Assembly adopted the rules of procedure of the Assembly, of the Executive Council, the ambassadors, statutes of the Commission, as well as the protocol of the Peace and Security Council. The Assembly extended the transition by declaring an interim period of 1 year. Now, strangely, as the Assembly was launching the Constitutive Act, Colonel Gaddafi presented proposed amendments to the Constitutive Act. The main proposal included in the area deletion of the article on reservations according to him, because according to him, it constituted, sorry, not reservations. The proposal included deletion of the article on withdrawal, the article which allows a member state to withdraw from the Union, because according to him, it constituted an invitation to states to withdraw. There were also other items that I don't need to go to. This item was deferred. Gaddafi also proposed the establishment of a single African army, again at the inaugural session, but this was rejected. The Assembly agreed rather to the adoption of a common African defense and security policy. Now, after the summit, the interim chairperson then led a delegation to Libya to try and persuade Colonel Gaddafi that it was too soon to start amending the Constitutive Act, and that most of the proposals would make no real change in any way, in any event. Because under customary international law and the Vienna Convention, whether a treaty says you can withdraw or not, one can still withdraw under certain circumstances. For example, the UN Charter has no provision on withdrawal, but Indonesia still withdrew or attempted to do so, depending on one, at least for several months, depending on how one looks at it. We failed to convince him and ended up helping him to redraft his proposals to align them with Union instruments. Now, the protocol was subsequently adopted in 2003. Now, one positive development from the adoption of the Constitutive Act was that there was a strategic plan 2004-2008, which came up with a new budget. And the budget of the African Union moved from $43 million under the OAU to $260 million, more than 6 times, as the first budget adopted under the framework of the African Union, which allowed the Union to then to undertake more projects and activities. As I move to another section of the Union government project, another section which will be on the Africa, on the Union government, I recall the words of Thomas Sankara, a Pan-Africanist revolutionary who served as president of Burkina Faso from 1983 until his assassination in 1987. He said, "You cannot carry out fundamental change without a certain amount of madness. In this case, it comes from non-conformity. The courage to turn your back on the old formulas the courage to invent the future. It took the madmen of yesterday for us to be able to act with extreme clarity today. I want to be one of those madmen. We must dare to invent the future. And I think Professor Hajer somewhat called us to reimagine a better future than the one we have. Now, it seems to me that those sentiments were inherent in Colonel Gaddafi's DNA. Although his proposals often were misguided, there is no doubt he was deeply committed to African unity. I believe he wanted to be remembered as a champion of African unity in the mode of Nkrumah. His close collaborators confided to us that when Libya had a dispute with Malta on the International Court, at the International Court of Justice on the continental shelf, he was not bothered about the briefings he received. When it came to African unity, every single initiative was conceived by him personally, not by experts or his collaborators. He would just call them to take notes. I witnessed that several times. When he was chairperson of the African or the AU Assembly for 1 year, 2009 to 2010, he summoned and sent an aircraft to pick the AUC chair, Jan Ping, to go to Libya 14 times in 1 year. I accompanied him in many of those trips. That year, he also traveled to the headquarters 3 times, often without notice, and if there was notice, very extremely short notices. Now, let me move to this union government project. At the January 2005 summit, which is 3 years after the adoption of less than 3 years after the adoption of the Constitutive Act, or rather after it had been launched, Libya introduced 4 interrelated items in the agenda of the Executive Council and the Assembly. The items proposed inter alia the creation of the post of Ministers of Defense, Foreign Affairs, Transport and Communication, Foreign Trade, and the cancellation of customs and the harmonization of custom tariffs among member states. The debate on these fairly straightforward proposals went on for 6 years and evolved into the deliberations on how to strengthen our common institutions with various options for a strengthened commission, a union government, and an African Union authority. Out of those 6 years, 4 were devoted to the deliberations around the union government. Of those 4 years, there were 8 ordinary sessions of the Assembly devoted to this issue, 2 extraordinary sessions of the Assembly, as well as 2 special sessions of the Assembly. There were also 3 successful committees of heads of state, one chaired by President Museveni, then Obasanjo, then Kikwete, which met severally in different places and made recommendations. At the level of the ministers, again, 8 ordinary sessions, 3 extraordinary sessions, 3 ministerial retreats in different places, and several sessions of ministerial committees. In addition, the Assembly as a whole devoted the ordinary session of the Assembly in Accra, Ghana in July 2007 to 1 single item. There were no other items in that ordinary session of the Assembly. It's the only time it just happened. And the item was the grand debate on the union government. Some of the issues addressed in the various sessions included the steps needed for the realization of this objective, the structure, the process, the nature of the consultations to be undertaken, identification of the contents of the union government concept, identification of domains of competence, and their impact on the sovereignty of member states. The other issues were definition of the relationship between the union government and the regional economic communities, elaboration of roadmap together with timeframes, and identification of additional sources of financing the activities of the union. And I should have underlined that in all the sessions that I referred to, the Assembly reaffirmed that the ultimate goal of the African Union was full political and economic integration leading to the United States of Africa. Now, another outcome of the grand debate in Accra was that the union government should be built on common values, that need to be identified and agreed upon as benchmarks. It should be a union of peoples and not just a union of states and governments. The African diaspora should be involved. And number 4, an audit should be conducted immediately on the AU organs, their power, their functions, and so on and so on. Subsequently, a high-level panel for the audit of the African Union was set up, led by the late Professor Adebayo Adedeji as chair of the panel. The report, containing 159 recommendations to galvanize the integration process, outlined 8 benchmarks, which were crucial to the realization of the African Union Government Project. While this was ongoing, in the summit in July 2005, Libya submitted new proposals to revise the symbols and emblems inherited from the OAU, the establishment of a Pan-African stock exchange, and a mechanism for participation in bilateral summits between Africa and certain states, because you had a situation where one state would invite all African, one foreign state would invite all African heads of state, and they would be there, all of them from Africa, with facing one head of state. At the end of all this, and by the way, there was also at some other stage proposal to establish an African television channel. At the end of it all, after back and forth, and all the meetings and deliberations I've outlined, at the session of the Assembly in February 2009, the Assembly decided that the appellation of a union government was a misnomer and would create confusion. It was asked, how could you envisage having 2 governments in Addis Ababa, one a federal government for Ethiopia and one for the continent? The Assembly therefore decided that rather than a union government, we should have an African Union authority, and that their authority should be a strengthened commission with a structure comprising of the president, the vice president, and secretaries, with portfolios based on areas of shared competencies as agreed upon. At the Assembly's request, the Commission prepared 11 legal instruments, including amendments to the Constitutive Act itself, the rules of procedure, etc., and some new instruments, which were considered by 4 different meetings of experts and ambassadors at different times, 4 meetings, and subsequently by the Executive Council and the Assembly. And I believe my friend Dondea was involved in some of those meetings. At the next Assembly session in July 2009, Libya requested for a reconsideration of the decision on the transformation of the African Union to the authority. Libya felt that this was a climb down from the earlier proposal to establish a union government, but this request was rejected. During the armed conflict that began with peaceful protests against Gaddafi's regime, and which escalated into a full-blown civil war up to October 2011, when Colonel Gaddafi was assassinated, this issue took a back burner. Finally, after several deferments, the proposal of an African Union authority was laid to rest in January 2013, when the Assembly decided to set aside the process of converting the AU Commission into an authority and to just strengthen the existing commission. This brings me to my concluding remarks. As I had said earlier, the Abuja Treaty envisaged that by 2028, that 4 years after its entry into force, we should have had full integration of all the sectors and the establishment of a single domestic market, a Pan-African Economic and Monetary Union, the African Central Bank, and a single African currency. The SCFTA agreement is an improved and more elaborate version of the Abuja Treaty, in my view. Nevertheless, I believe this new initiative has taken us back closer to where we began than where we are going. I have 2 more remarks. The second one, The continental integration process has been a compromise between those who preferred a revolutionary approach and those who preferred a gradualist approach. According to President Thabo Mbeki, during the debate on the CETA Declaration on 9/9/1999, the difference in approach was, according to him, I quote, between those that wanted to run and those who wanted to walk. End of quote. Evidently, most of our leaders prefer walking, and slowly for that matter. However, I would suggest that a third group existed, and that is for leaders who want to walk but briskly. Third remark, and my final one, it is true that every major cause must have a leader. In Europe, Jean Monnet was the unifying force behind the birth of the European Union. In Africa, it was undoubtedly Kwame Nkrumah in the late 1950s and early 1960s until the coup of 1966. In the 90s and 20s was Gaddafi. During those two periods, there were other leaders who shared that vision, but none as strongly. However, with the assassination of Gaddafi in October 2011 and the exit from the stage of some leaders who preferred walking quickly, that vision seems to have been laid to rest and seemingly without a decent burial. I thank you for your attention.
Thank you so much, Judge Ben Kioko. That has really been a sort of a masterclass on the evolution from the OAU to the AU. And as I've understood it, also a dignifying retelling of people like Colonel Gaddafi and their efforts in the developing of the AU. So we'll move on to Dr. Ibrahima Kane. Dr. Ibrahima Kane is a Senegalese lawyer and a human rights advocate. He's a special advisor to the executive director of the Open Society Foundation Africa, where he leads the advocacy at the African Union level. He has worked closely with and argued before the African Commission on Human and People's Rights, the African Union Commission, the African Committee of Experts on the Rights and the Welfare of the Child, the Court of Justice of the Economic Community of West African States, and the Court of Justice of the East African Community. He has also previously served as Associate Professor at the University of Essex Law School from 2005 to 2011. Dr. Kane will discuss the governance architecture under the AU Constitutive Act. Please welcome Dr. Kane.
Thank you, my brother, for inviting me to this gathering. And I really want to recognize Judge Ben Kioko, Professor Hajer, who are really very important actors in the African, political system. Both of them. One was a legal counsel, the other one is the current legal counsel. You introduced me as working for the Open Society. I used to work for the Open Society. I'm now retired from the Open Society. I also want to really let the people who are participating to this discussion know that I really was part of the conversation from almost 2002 up to now, to the discussion on the evolution of the African Union. And I really want to thank Ben Kioko, who allowed me in many, many places to participate in the conversation. The African Union, we like it or not, is an institution. And institution, as one of my professors used to say, unlike satellites, institutions rarely remain in the orbit of their creators. Events, circumstances, personalities of the people who embody them determine the trajectory. Ben Judge Ben Kioko mentioned to you the role played by Gaddafi, the role played by Kwame Nkrumah, but there are also many other people, many other presidents, Ben Bella, King of Morocco, Hassan II, Nyerere, Kenneth Kaunda. You know, you can cite a number of leaders of this continent who played an important role to ensure that Africa has a mechanism and Africa plays an important role. The former Senegalese president, Léopold Sédar Senghor, for instance, is behind the creation of the position of the head of the AU. It didn't exist at the beginning, but politically they tried, they did everything. You know, all of this to tell you that leadership is really key on the trajectory of this institution. If there is no leadership, nothing will ever. And the leadership at this level is at two important levels, if I can put it in that way. Is at the level of the states, because don't forget, AU is created by 55 African states. If there is no leadership in those 55 countries, it will affect the functioning of the institution. But if there is also no leadership at the level of the AU itself, it affects all the work that the AU will be doing. And we need to look at this leadership at those two levels. And also, we can even expand the issue of leadership also at the level of other actors, you know, because AU is not only the state, the leadership in Addis, but it's also civil society organization. It's also many, many actors who contribute to this work. And at that level, I think, you know, when you look back, you look at what is happening today, when the crisis in between Rwanda and the DRC is not sorted out in Addis, but sorted out in Doha. You ask yourself, where is the AU? Where is the AU leadership? And what have we done in the last 25 years to do this? And for me, it's really a kind of wake-up call, because at the beginning, and I recall at the beginning, the leadership that was there, one, the leadership of Alpha Umar Konare, who was the first chairperson of the AU, and the leadership of, you know, Ben Kioko mentioned Thabo Mbeki, should have mentioned the president of Algeria, Abdelaziz Bouteflika, President Olusegun Obasanjo, Meles Zenawi, Abdoulaye Wade, who played an important role to ensure and to build the institution. You know, these together played an important role to build this institution. These are the kind of leadership that we are not seeing anymore. You know, it's not a surprise that apart from the AU, all the regional economic communities now are collapsing because of the lack of leadership, because of the lack of, you know, people who can really support these ideas, who can really make sure that these ideas are alive and that everything is done to really make sure that the provision that Judge Ben Kioko mentioned to you are fully implemented by African states. You know, this lack of leadership led to a situation whereby, you know, for instance, when you look at the military coup in Africa, in 1999 in Algiers, the decision was taken that Africa will never accept any power that any military power on the continent. That declaration in Algiers was accompanied the following year by a decision in Lomé to really make sure that all the military that come to power have to hand over the power to civilian, because Africans believe that civilians are the only one who can help. We had in 2007, not only in the Constitutive Act, that principle, but in 2007, the African Union adopted a treaty, the African Charter on Governance Election, to really make sure that the military coup are finished on the continent. And even if a military civilize himself, he will never get to power. Look at the reality today. Egypt, the president came to power, is a military, he remains in power. The latest being Chad. Up to now, we even don't know what happened after the killing of the president in Chad. What kind of system that we had in the country, because African institutions were unwilling, I say unwilling, to determine if what happened in Chad was a coup or not a coup. And if you lack that ability to make a decision on these issues, new situation will happen, and those situations will continue to undermine the authority. That's what exactly happened in Niger, in Burkina Faso, in Mali, in Guinea-Conakry. And now, this unconstitutional change of government is in jeopardy. Is in jeopardy simply because of the lack of, leadership, the lack of governance, the lack of, and that for me is really a shame, because what was built in 2000, from 2000 to 2002, was really what could help Africa to have its own place in international relations. Because at that time, we have the leaders who wanted Africa to be a significant actor in the world. We had at the AU level, I remember the meeting that was held, and Ben Kioko was at that time legal counsel, where for the first time in Africa, the AU adopted a strategic agenda for 5 years. And that strategic agenda program was adopted from the beginning to the end, was elaborated by Africans. And when that document was presented, all the 50, at that time there were not 55, but all the 53 countries that attended the meeting was satisfied by the way that Africa was presented, the way Africa wanted to deal with its own issue in the next, for the future. And even but for the first time, a budget was presented to the AU saying, if we want to realize this, we need at the minimum $600 million a year to do that. Everybody was clapping, everybody was happy, and somebody was even telling to Professor Alpha Umar Konare, I like you because you make us dream. And when you make us dream, it helps us to avoid the nightmares that we had in the past and to avoid the nightmare. And, that was the spirit at that time. But look at it today. The first 10 years evaluation of the implementation of the Agenda 2063 that was done 3 years ago said its conclusion was, in 10 years from 2013 to 2023, in 10 years, Africa spent 76% of its resources to resolve crises in Africa, and less than 25% to try to deal with the problem that Africa is facing. You know, I don't need to describe you the problem that we are facing at the moment. Which continent, even which country can survive when 75% of your resources is really dedicated only to peace? That's, again, a problem of leadership. Because if we had leadership, we would have sorted out this problem. We have sorted out. Look at what is happening at the moment in Sudan, a country that is completely destroyed, and the AU is not able to tell us how this question, this issue, the problem that the country is facing will be sorted out. But people are looking for Riyadh in Saudi Arabia or looking for the US to find a solution to this problem. We talked about the death of Gaddafi. Look at how Libya is looking like today, a completely divided country. And all these questions, at the end of the day, call for the necessity for African to really look at how we can create a new leadership that can lead us to really realize the promises, the aspiration of the Agenda 2063. If we don't have the leadership at home, if we don't have the leadership at the AU level, if you don't have the leadership in the regional economic communities, it will be difficult for us to realize that agenda. I don't have the solution. You don't have the solution. The president of Rwanda was given a task to reform the AU. That reform of the AU collapsed. We need to be frank. Apart from the election, the new mechanism of election of members of the AU, nothing else have worked so far. It's even going from bad to worse. I think the time has come for all of us. And I could, because this meeting was called by civil society organizations, by academics, I think the time has come for us also to really start doing something that will help to not to reconvene, but to rethink the way our institutions are performing, to really see how can we contribute to the work. People that are working at the level of these institutions are very remarkable people, very knowledgeable people, very, people who want to bring something to the AU. But if we don't have a leadership, the contribution of those people cannot be useful. So for me, again, it's for us to really try to find a way of making sure that we had leadership at the local level, we have leadership at the regional level, and that leadership will then be reflected at the continental. Without those leadership at the local and regional level, we cannot, there is no hope to have a leadership at the continental level. And that's the reality of the continent. I'm sorry because I wanted to say more, but I think here, these are, to my view, the key problem that we need to deal with. And we need to, the next time any reform of the AU is conducted, it should not be just a discussion among leaders. It's a discussion among leaders and the people of the continent, because we have our say, we have our view, and that needs also to be taken into account for the changes that we want. The Agenda 2063 is the only that we have so far, and we need to make sure that is implemented for your generation, because 2063, I'm sure I will not be there, but for your generation, we need to contribute to create the condition. Africa is only 5% of the economy of the world. Africa is insignificant in international relations. But Africa is 55 countries, almost a third of the countries in the world. We need to really pay attention. And when you look at our resources, we look at the position of the continent. The chances that we have to play an important role is so big that you said, the lack of leadership is just destroying us. And that is the problem. Elvis, this is what I wanted to say. Thank you.
Thank you. Thank you so much, Dr. Kane. I think you really show this leadership quagmire. You put these bifurcated levels of the state level and the AU at the AU level. And as you close, I think there are some similarities of what you're saying to what Prof. Hajer was saying in the beginning, a certain level of democratization in the decision making, in the reforms of our beloved institution. So I'll move on to our last panelist, who is Dr. Apollin Koagne Zouapet, who is a Cameroonian legal scholar with a PhD in public international law from the University of Geneva and a diploma from the Hague Academy of International Law. He currently works in the legal department of the International Court of Justice as a legal officer. He's also the editor of an open access book titled 60 Years After Independence, African International Law, Views from a Generation by Pretoria University Law Press in 2023. And I should say his introductory chapter where he argues for an African approach to international law is quite worth the read, and especially for us who are interested in third world approaches to international law. Dr. Zouapet will be discussing the financial architecture under the AU Constitutive Act. Please welcome, Dr. Zouapet.
Thank you, Elvis. First, I would say that I'm not supposed to discuss the financial architecture. What has been asked by Humphrey was to discuss the AU Constitutive Act and the progress of an African international law or African approaches of international law. But before, I want to thank Humphrey for inviting me, and Don Deya also. I also want to say how much I'm proud, I'm happy to be part of this panel with eminent people like Josh Ben Kioko, Professor Gueldich, and Dr. Ibrahima Kane. The second thing I want to say is that I'm not an insider. I'm not an insider. So I'm not like Josh Ben Kioko or Professor Gueldich, who as legal advisor of African Union have know more the process and use on a daily basis the Constitutive Act. I'm not also someone involved in the discussion at Dr. Ibrahima Kane. That's why maybe Humphrey asked me to discuss more about it also an academic perception. So I'm not going to discuss the drafting history, the implementation of the EU Constitutive Act, or even the governance architecture that has been done by Dr. Ibrahima Kane. I'm also not going to discuss the evolution or the changes between the Constitutive Act and the OAU Charter. What I've been asked to discuss and is linked to what you said about my current research about an African approach to international law, because as Ibrahima, I think that African, unfortunately, do not have a great width, not only in international relations, but in general in international law. And when you think about it, you should remember that in the aftermath of the independence, one of the very first things of African states was to contest the principles and rules of international law, which have been which have been tools of colonization of the continent. So they were contesting the rule, arguing in a just way, on my point of view, that those rules were mostly European international law, which have been internationalized. So there was expectations, at least that 40 years later, when the AU Constitutive Act was adopted, that at least we found in that the Constitutive Act some elements of a real African approach to international law. And I define an African approach of international law which should be different of simply African international law. So in one hand, you can have treaties, convention, adopt within African organization, which by the formally African instruments, African international law. That's not what I consider being African international law, because you can have universal principles enshrined in African instruments. What I define as African international law is a proposal coming from Africa of an international law based on shared African values, on shared African perception and conceptions of the society. So that's for me the idea I put behind the concept of African international law. So the point of view of my reflection is that AU and George Ben Kioko showed the fight between the Monrovia and the Casablanca groups. But my point of departure is that AU is supposed to be the institutionalization of Pan-Africanism. And based on that, to respond to the question, does the AU Constitutive Act enshrine or being the starting point of an African international law? My first response is no. My first response is no, is that when you read the AU Constitutive Act, you have a proclaimed Pan-Africanism which is inspired and rooted in universal values. And to defend that idea, I'm going to propose two main proposals. The first is the lack of institutional originality. Even the name of the organization, African Union, when the name African Union was chosen, the first reference was European Union, and Gaddafi himself admitted that he was kind of guided and inspired by the success of the European Union. And during the discussion in Lusaka in 2001, many references were actually done to the European Union, and even the institution in the African Union Constitutive Act lacks originality. Most of them, if not all of them, are kind of mimicry of the European Union institution. So you have the Assembly of Heads of State, which is a copy of the European Union, European Council, the Executive Council, which is the Council of Ministers, and some organs have the same name, like the PRC, the Parliament, the Court of Justice, the Commission, and the ECOSOC. So on that point of view, there is no originality. There is nothing African in the institutional architecture of the African Union itself, even if in some protocol, as the peace and security, you are going to see some originality with the Council of Wise and so on. But in the Constitutive Act itself, when you read it, it's just a traditional Constitutive Act of an international organization with no originality, with nothing on the institutional part coming from showing something original and linked to the approach, the different approach African states can have about international institutionalization. The second thing about this lack of originality is the principle themselves. When you read the principle of the African Union, you'll find what I can call the universal principles. The principle which was already existing when most of the African states accede to independence. If you take a principle as the prohibition of the use of force, the peaceful coexistence, the respect for democratic principle, and good governance. These principles are just a repetition of what you can see in the UN Charter or in the Constitutive Act of other international organizations. What is more problematic and what can maybe be part of a more important debate is the inclusion in the Constitutive Act of some controversial principles as the uti possidetis juris principle, which is in Article 4B. And some of those of you who are familiar with the jurisprudence of the International Court of Justice know that 3 months ago, the court released a decision in the case between Gabon and Equatorial Guinea about the maritime delimitation. And one of the dispute was settled mainly on the basis of colonial agreements. And Judge Yusuf wrote a dissenting opinion where he was really critical about this approach of the court. And he was saying that the uti possidetis juris, as it was adopted by the court does not reflect really the approach of the OAU at that time. But if you have that idea, and finally, if you have the logic of Pan-Africanism and the idea highlighted by George Ben Kioko that we are in an approach of progressive state, you can wonder if the principle of, they call it principle related to the respect of borders on achievement of independence. If this principle is not a kind of freezing the project of Pan-Africanism, it's that principle is not finally a kind of obstacle for any move to a more integrated African continent. And I agree with George Yusuf that there was place when drafting the AU Constitutive Act to introduce in a more nuanced way the idea of Pan-Africanism, at least on the principle, and to introduce the idea that it is possible in the future to move for a more united, a more integrated Africa. The second idea, because I know that we are running out of time, the second idea is that even if the Constitutive Act is mainly based on a mimicry of the European Union, if the African Union Constitutive Act has a lot of principles which are finally simply a kind of repetition of universal principles, you can find in the Constitutive Act some elements, some seeds of an African vision of international law. And here also, I want to underline two main elements. The first element is that the AU succeed in kind of consolidating the original vision of the AU Charter, an external international law of resistance and liberation. So you still find in the AU Constitutive Act all those principles which were in the OAU and which were the base of the fight against colonialism, which was the fight for the liberation of the continent. So you are going to find that at least 4 of the principles which were in the OAU, and it was the principle which the main aim was to fight colonialism and to fight for the liberation of the continent are still in the AU Constitutive Act. And this is something important because I guess that the drafters of the AU could have considered that, colonialism is ended and that now we have to move forward and that we don't need this principle anymore. And as I said, they took only 4 principles out of the 6 you have the OAU Charter. So they decided at least two of them were not more accurate, but at least 4 of them were still accurate for the liberation of the continent. That's something really important, and that means that there is a kind of continuity, at least in the struggle for the liberation of the continent between the OAU and the AU. The second sub-idea on those principles is the new principle in the AU Constitutive Act, which formally are not coming from the OAU Charter, but which can be linked to the principle in the OAU Charter. So you have the principle as the acceleration of the social integration of the continent, the promotion and defense of African common position on issue of common interest, the promotion of peace, security, and stability of the continent, and the common defense policy of the continent. So you still have this idea already in the OAU Charter of the liberation of the continent and on the trying to build a continent which is capable to resist the attacks of the other continents. So you have in the AU Constitutive Act this idea of an African international law which is mainly a law of resistance, which is mainly a law of liberation of the continent. So you have this continuity between the OAU Charter and the African Constitutive Act. The second, and that will be my last idea, is the formalization of a new vision in the Constitutive Act. And that new vision is kind of built on what was done before the Constitutive Act itself. And one of the main pillars of this new vision is the African Charter of Human and People Rights. And then the head of state of the EU, and as George Ben Kioko explained, kind of draw some conclusion on the fails of the OAU. Like, for example, they fail to effectively represent the interests of the people. So you have in the AU Constitutive Act the idea of a new African international law, which is an African international law, which is an intra-African law of solidarity and protection. So as I said, in the OAU, if there was a vision of a vision of international law, an African approach of international law, it was mainly an international law of resistance and liberation. In the AU Constitutive Act, you have for the first time a kind of a reflection on the protection of solidarity. So the AU Constitutive Act first makes the peoples of Africa the main element of the integration process. So, and for me, there are two principles which enshrine the best this approach. The first one is the principle of in Article 4H that we know all, the right of the African Union to intervene under certain conditions in case of gross human rights violation, crime against humanity. And it's the first time actually in the history of international law that we have a clear provision in a treaty, in an international treaty, which gives such power to an international organization. Of course, we can have a debate, and there has been a lot of work around the question to know how this Article 4H is compatible with the UN Charter on the power of the Security Council. What is important here is that the AU, for the first time, kind of put a limit to the principle of sovereignty and the principle of non-intervention. In the framework of the OAU, the principle of non-intervention was kind of cornerstone with a lot of consequences and a lot of violation of human rights. In the AU, you have this new idea that because the people are the most important elements of the African continent, we have this idea of protecting those people. And the same idea of intra-African law of protection and solidarity is also found in Article 4P with the condemnation and the rejection of unconstitutional change of government. And once more, here, the Africa kind of draw conclusion on its history. The AU was able, based on what happened the years before, to see that one of the main problems of our continent, and Dr. Ibrahima Kane underlined it, is that one of our main problems are conflict. We spend too much energy and time trying to deal with conflict. And the basis of most of that conflict are the question of governance and democratic governance. You can just look in our continent, the number of contested elections or the number of coups d'etat in our country. So for me, these are the two elements. At least there are others, but we don't have time to discuss. But my idea by taking these two examples was to show that in the African Union Constitutive Act, we have some seeds, some elements of a new vision. But unfortunately, the continent have not been so far able to build on these seeds, have not been so far able to kind of give full result to those seeds we have in the African Union Constitutive Act. So I'm looking forward to see how the continent will be able to move from an international law of resistance and liberation for a real international law of solidarity and protection. And this is the next thing, because the African Union vision, the African vision of international law is not supposed to stay on the continent. It should be a proposal to the world and how the African continent will be able to propose these new rules at the universal level. So that's quickly what I can say on this issue of how the African Union Constitutive Act kind of put in place an African vision of international law. Thank you very much.
Thank you so much, Dr. Zouapet. Really interesting observations, and I have a couple of questions for my own, but I want to segue into the Q&A session, the question and answer session. So please use the Q&A chat function for our over 50 participants, and as they are going to write the questions, I have a couple. I'll direct them to some of our panelists. So the first one is directed to Judge Kioko and Professor Hajer. In preparation, I read a paper by Professor Tianjana Malua in 2020 where he discusses the contribution of African states to the development of international law, and he uses the multilateral treaties. So in the treaty making, he argues that it is both in the formal proposals by states and also informal contacts and discussions by the diplomats. So my question here is, how much so was the Constitutive Act for you, Judge Ben Kioko, and perhaps even for Professor Hajer, these new treaties that stem from the Constitutive Act, were they developed through these more informal contacts and discussions as much as they also proposals made formally? Yeah, that's my question to Prof. Hajer and Judge Ben. And a question to Dr. Zouapet. I'm trying to see correlations between the democratization that Prof. Hajer was talking about and also Dr. Ibrahima Kane, and your perception or your proposition of what constitutes an African approach to international law. So would you argue that the below of international law, to use Professor Balakrishnan Rajagopal's work, and this includes the grassroots movements, the women movements, that the people who should actually be involved in charting the values and these ideas that would make an African approach to international law? That's my question to you, Dr. Zouapet. So I welcome more questions in the question and answer session, but we could start with those questions. And please, the other panelists can also respond to what was said by previous panelists. Thank you so much. We could start with you, Judge Kioko.
Thank you very much, Elvis. I think it's important to underline that within the framework of an international organization, at the end of the day, the decision as to whether to prepare a draft instrument or not comes from the states. But often it is the Secretariat, or in this case, the Commission, that is the engine of ideas. And the Commission would perhaps come up with a policy brief on a particular area where the Commission feels this is an area that needs to be addressed by member states. And then out of the discussions, there will be maybe proposal coming in on preparation of a treaty. For example, I can give you two examples. One is or maybe not just a treaty, but an important policy soft law instrument from the Union. For example, the Mechanism for Conflict Prevention of 1993 was based on a paper that was prepared by the Secretariat and the leadership of Dar es Salaam, saying that we must do something about conflicts on the continent. And out of that, you came up with the mechanism. There are a number of treaties, one would say, also arose from that. For example, like the process of establishing the African Court of Human Rights was basically, and I think I'm confirming what you said, Professor Malua said, that was from out of informal discussions. There were seminars organized by the International Commission of Jurists and the legal division of the OAU, looking at how to strengthen the African human rights system, and seminars of African ambassadors were organized and so on. And out of that, it was felt that in the decision of the African Commission on Human Rights, there should be a paragraph requesting the OAU Secretary General to convene a meeting of experts to look into the possibility of establishing an African Court of Human Rights in order to strengthen the protection of economic and social and cultural rights. And that's how the process of drafting the protocol on the African Court arose. So yes, formal, informal, but I think by and large, it is difficult to say that the treaty arose from the informal because there would have been a document submitted. And out of those discussions, then came the idea of an instrument, of a legal instrument. And if you allow me, Elvis, just to confirm what Ibrahima said, and to say that Ibrahima, actually on the work that has been done by the OAU and AAU on civil society engagement, Ibrahima has been a very key player, very key partner to the institution. And actually some of the ideas that he submitted to the AAU on informally were incorporated into some of the work that was done by the Secretariat and by the Commission. And of course, others, not just Ibrahima, Chidionel Kalu, Dea, and others. Thank you.
Thank you, Professor Hajer. And perhaps for you, it could also be the other new conventions like this AU Convention on Ending Violence towards Women and Children that was adopted this year. Yeah, please. And also, Dr. Ibrahima Kane, you can also jump in because you are equally an insider, to use Dr. Apollin Zouapet's words during this whole past 25 years. You could also come.
Well, I don't know if Prof. Hajer is not available. I can give the example of the protocol to the African Charter on the eradication of statelessness and the right to a nationality. You know, this work was a joint initiative of the African Commission on Human and People's Rights based on its own assessment of issues related to nationality, related to statelessness, and the fact that those issues were more and more creating more problems on the continent, particularly the situation in Côte d'Ivoire in the year 2000 and the invention of the Ivoirity as an ideology and so and so. And the commission, when the commission decided to do some work on this, the commission invited some other African scholar and activists to discuss the issues. That's where African also, the commission itself, but also the AU discovered that we needed to decolonize our legislation on the nationality, because all the legislation of African countries, except one or two that never had, that never been colonized, were based on colonial law. So this idea, it's only in this treaty that you find provision that are dealing with issues that have never been dealt with in other countries. For example, pastoralism and nationality. The kind of succession of states when a state is divided into two, Ethiopia, Eritrea, South Sudan, Sudan, the problem of the territory of Bakassi, which was taken from Nigeria to get, and the international law, and Apollin can confirm that, in its decision didn't deal with the issue of population. They just deal with the territory. It's only on another case regarding African countries, Niger and Burkina Faso, I think, that for the first time, the International Court said, yes, there are people who live at those borders, and we need to look at their legal situation. But Africa preceded that kind of conversation. So I think in many areas that you can see, and even the idea of decolonizing international law in that particular regard, taking this issue of nationality as just a state right to a human right was also something very important. So I think those kind of things are really very important. And slowly Africa is going towards that line, dealing with some of these issues. You take the protocol on the right of women. There are thousands of many provisions in that protocol that are unique to the continent, don't exist anywhere. So I think as far as international law is the contribution is becoming more and more real, and people are doing well in that regard.
Yes, thank you so much, Dr. Ibrahima. We could go to Dr. Zouapet, and then we'll go to the two questions in the Q&A. Thank you.
Yes, quickly. I will first, if you allow me to start what Dr. Ibrahima Kane said. You know, the problem actually is that if the court doesn't refer to the population, most of the time because of the pleadings of the African states. And if you read the opinion of the dissenting opinion of Judge Yusuf in the case in Gabon and Equatorial Guinea, he recognized that one of the problems is that actually the parties were discussing the colonial agreements, and it's the same. And one of the issues we have, see, if you are thinking about an African approach of international law, is who are the lawyers of African states? And you know, unfortunately, our continent, 60 years after the independence, still when they will have to appoint their lawyers, their counsel, always use Western scholars and Western lawyers. And of course, those Western lawyers and scholars are trained based on Palma Island decision, you know, of Maxi Bay. Of course, they have this vision. So that's the first thing. The second thing is that even when the African states have to appoint ad hoc judges, most of the time, they appoint Western, you know, in the case of Gabon and Equatorial Guinea, the judge ad hoc appointed by Gabon was Monica Pinto from Argentina, and the ad hoc judge appointed by Equatorial Guinea was George Wolfram from Germany. So I think sometimes, you know, we are part of the problem. We are part of the problem. If you want to bring African solutions, if we want to bring African vision, African value, we also have to work on that in our cases. On your question, Elvis, quickly, I think I agree. I think that, as I said, you have in the AU Constitutive Act this idea of the principle of participation of African people in the activities of the organization. And this is something really new. This idea of having, you also have this idea of broader participation, not only of civil society, but also of women and youth. And you have, of course, the Charter on Youth and the Protocol of Maputo on the right of women. Yes, I think, at least on the principle, we have this democratization of the organization, this democratization of the integration process. But also, there is a gap between the proclaimed principle and the way we put them in practice. And I think George Ben Kioko and Professor Hajer, who daily deal with discussion, can explain why we have this gap between the principle and actually their implementation.
Thank you so much, Dr. Zouapet. And maybe if I would jump onto that, seeing the previous Sudan case on the reservations, even their counsel were also not African. And in my positionality as someone who would want to occupy such spaces, it's a bit also demoralizing when you're only seeing people who are not looking like you in those spaces. Just to jump onto that conversation, I'll say these two questions, and then we'll listen to them and then go to the closing remarks by the panelists. So Andrew Songa asks a question to Dr. Ibrahima Kane, noting the various organs, can we say that these are underpinned by a coherent public participation philosophy, or have the organs embodied their own philosophies to public participation? What does this portend to the visions of a people-driven AU? I'll also move on to Martin's question. Martin asks, and he doesn't direct this, so we'll just move on to, we'll ask all panelists to answer this. He asks, AU was in 2023 made a member of the G20. Is this membership likely to have a positive impact on the African countries in the same manner the EU voice at G20 has on the EU member states? Secondly, what are the prospects of establishment of African Court of Justice, and as was envisaged in the AU Constitutive Act. We have a final question by Patience. Patience Chepchirchir, who is an editor with us in Kabarak Law Review, asks, her question is regarding Article 30, which Prof. Hajer spoke about. What is the effectiveness of the implementation of that article, given the recurrence of illegitimate governments in African countries? Thank you so much for these questions. We'll move on to the answers from the panelists. We can start with Dr. Ibrahima. I've seen Judge's microphone.
No, it's okay.
Yeah, please
no,
go.
Okay. Ibrahima can start.
Okay.
Yeah. Well, regarding the participation of people to the functioning of the AU, that's the question, I think. Ben Kioko can tell you when the discussion started with CIRT and others, there was no participation of civil society. But before that, particularly, and I need to really highlight here, and that is also leadership, the leadership of Salim Ahmed Salim, who for the first time accepted the participation of civil society in AU proceeding, given the fact that AU countries didn't even want civil society to participate, but it created spaces for civil society to have that kind of participation. And that participation led, when the drafting started of the AU Constitutive Act, to give space to civil society. But you see, when they gave us space, they wanted to control us. When you look at the document, because the civil society participation to the AU is organized within ECOSOC. ECOSOC doesn't have a protocol. ECOSOC has a statute. And that's the reason that they put the statute is that they can change things anytime they want regarding civil society participation. And that tells you about the mentality of those who were drafting at least the majority of the state. And I recall when even the Constitutive Act came into force, now how to put in place ECOSOC, it was Ben Kioko can tell you, because he was the legal counsel at that time, it was a headache even to find the chairperson of that entity. You remember the late Wangari Maathai, who was chosen. There was a proposition to have the wife of the former president of Mozambique and others. You know, if for an institution that is supposed to contribute fully to the functioning of the AU, if this is the way that they organize even the leadership, it tells you that this is just an instrument, but it's not an institution that is really seen as an institution that can have a full contribution to it. And up to now, the ECOSOC is seen as the key to choose who can participate and who cannot participate in the AU functioning. If we really want to be an institution, you know, driven by African people, we should not put barriers. We should not put all those obstacles. We should allow people to go, like it happened in Latin America, it happened in Europe and other places. So, but and my conclusion is this, you know, despite all those obstacles, if African civil society, if African people want to be more visible, want to participate more in the proceeding of the AU, and if they pull their weight, they will have their space. It's an open way, but we need to have the leadership that can also play a critical role in opening the doors, in opening gates for civil society and the participation of Africa, like electing members of the parliament, you know, creating other places where civil society can fully participate in the conversation. We need ideas to change this continent. And those ideas are not just within the administration, it's with the people. Thank you.
Yeah, thank you. Thank you so much. Judge Ben.
Elvis, I didn't get the question on the court and the Constitutive Act.
Oh,
But
okay.
Martin, it was not clear to me.
So the second question was asking if what the prospects of the establishment of the African Court of Justice as was envisaged in the AU Constitutive Act. Like, what are the prospects? Yes.
Oh, I see. Okay. Oh, very well. I think my friend Ibrahima has more or less responded to this issue of public participation. And I think Ibrahima will agree that between him and I and Chido Ondinkalu and a few others, we really tried our best, of course, with the concurrence of Dr. Salim, to ensure that civil society is engaged in the activities of the union. And I remember that when we did the first ministerial conference on human rights in Mauritius in 1999, we had civil society representatives speaking to every agenda item that was being considered by the ministers. And later, when we had the convention on preventing and combating corruption in Africa, again, we had civil society representatives, including Transparency International and others, taking the floor with the right to take the floor, just like member states. But unfortunately, those examples do not apply to everything, and they are ad hoc. There are instances where civil society is given a full role, and others where they are not, and others where they are consulted peripherally. So it's still work in progress, unfortunately. With regard to this Court of Justice, the protocol of the Court of Justice was adopted in 2003. The one on the court in 1998, the one on the Court of Justice in 2003. It came into force, but it came into force when the protocol on the merger of the Court of Justice and the Court of Human Rights had been adopted, but was not yet in force, and is still not in force. And then there was the Malabo Protocol later on in 2014. Now, member states decided that although the protocol on the Court of Justice was in force, it should not be launched or operationalized, because now there's a major protocol that we need to wait for. And the issues around that were avoiding duplication because then you would have 11 judges of the Court of Justice sitting somewhere with all the financial outlay required, 11 judges of the Court of Human Rights staying also somewhere else or the same place, but it would have been a very expensive business. Because, for example, the African Court, the budget is about $11 million. Then maybe for the Court of Justice it would have been more. Although in the first few years, they will not have a lot of business, because the Court of Justice deals with disputes between states, whether it's tariffs or border disputes, etc., etc. So it has not yet been operations, but in the last 2 years or so, there seems, particularly from the reform process by President Kagame, there's been a recommendation to now operationalize the Court of Justice. And in January this year, it was decided that judges will be elected in July this year. I think it was after President Ruto had taken over. But that could not be done because the structure of the court, the structure of the registry, the financial implications are not been determined. And therefore, maybe next year it may be launched. Now, regarding this Article 30, I think Ibrahima again has responded to this. The problem is we are very good at norm setting, but extremely poor in implementation across the board. In fact, a study was done and shows that many of the decisions that have been taken at the level of the AU, the organs, including the court, are hardly ever implemented. The level of implementation It's probably in the 20s, the past 20 or 30%. So this issue of unconstitutional change of government has been implemented by and large, but there are cases where the wrong decision was taken, in my view. And I think Ibrahima mentioned Egypt, and I think there's also the other example of Chad, where clearly there was a coup, they should have been suspended. But somehow there's this thing about when you live in a glass house, you don't throw stones. And it is the member states who are supposed to be implementing this. And then they, for whatever reason, they don't implement it. And then there's nothing you can do about it. So by and large, been implemented, but there are some contradictions there.
Thank you, Judge. Because of time, I'd like us to close there with the Q&A, but I'd invite the panelists to give their closing remarks, and then we'll have Mr. Don there for his closing remarks. So let's start with Dr. Apollin Zouapet.
Thank you, Elvis. I think if I have to say something to close our discussion today, is that I think the Constitutive Act is a wonderful instrument. We have a lot of important principles, and I think today the debate, and I think no one raised the idea. The idea should not be to change, adopt a new Constitutive Act or create a new organization, because I think so far we have not been able to use all the resources of the Constitutive Act. So there's, as I say, there's a gap between the principles and the ideals you can find in the Constitutive Act and their implementation. So I think that today the main thing to do is to work on how to put in place, to put in practice the element of the Africa Union Constitutive Act. I want to be optimist, because I think now you have more and more Africans and young Africans and you and other people being more conscious that Africans have to build their own continent, and that we have enough resources to do that. And I remain confident that we are now having a good trend, and that we can achieve some good results in the near future.
Yes, thank you so much, Dr. Zouapet. I invite Prof. Hajer for her closing remarks.
Thank you so much. I just need to say few ideas. The first one is about the reforms. I echo what said Judge Ben Kioko concerning the future of the Court of Justice and the fusion of Court of Justice with Human Rights and People's Court. So this is a big and a huge chantier of reform. He said that normally the elected judge should be done, the election of the judges of the Court of Justice in July, because the President Ruto took the project of the reform from the President Kagame. However, I was there in the room in the summit in February, and I was online with the different drafting committee. They raised this, and they said we are not ready yet. And they said, for instance, let's keep having the dialogue with all the stakeholders, including the judge of the actual human and people's rights, so that we can see how we can do that. However, we have a slogan that said African solutions to African problems. And I think Khan said already that some of our conflicts are the solutions are in Doha, in New York, in Washington, in Paris, but we have our everything. We have our instruments, we have our legal background, we have our institutions and organs. The political will is the key. If we do not reach this political will, if we do not change mind, we never come to a solution. So this issue of the how to say, the instances, judicial and quasi-judicial. It's a huge reform, and the reform is ongoing. So let's be patient, let's be ambitious, but at the same time, let's be realistic. There is still a lot of challenges, budgetary challenges and constraints. We have human resources constraints. We have also this duplication, and all these issues should be really resolved first so that we can have efficient and good institutions. The second one is the issue of rules of law, democracy, human rights. This is not a luxury for Africa. Yes, it is in our Constitutive Act and in all the other instruments added to Constitutive Act. However, do you think that we believe in rule of law in our African countries? Still, we are behind, and this is an issue for the future generation. You need to believe in it. You need to change mind. And you have one of the most important issues that we have to combat is corruption. Corruption is a problem. It's a great challenge, and the corruption, if we fight it, we can reach at least minimum of rule of law, democracy, and human rights. But I think it's a process, and as I said, it begins on education. It begins in our schools, in our families. If we believe in ourselves, change will come, and the wind of change will come. Last thing is that we need to have hope. We need to still have hope. We need to match these ideals, these principles with the context. I listened carefully to the different panelists. All of us, we agree that still there is gap, and to match these principles, these ideals to reality, I think still the work should be done for all the stakeholders. It should be multidisciplinary and multifunctional, and let's go to on the people involved, not only, as I said, leadership. We lack leadership. For instance, let's have this leadership like in Nkrumah and other Pan-Africanists at the 60s, like Muammar Gaddafi, and the people, the Senghor, and the people who believe really in the fact that Africans are a unity and they should keep their common interests together. I do not see common interests. For instance, it is selfishness, and everyone is fighting for its own interests. But if the leaders try to find this common understanding of what is Pan-Africanism, things will move. So that's why I said still hope is there if our future generation work on it seriously and change, and knows that in the global arena, if you are not united and solidarity, you will lose. That's why I said this is not a luxury. We need really to believe in all these ideals so that we can reach them and so that we can make the change. Thank you so much.
Thank you, Prof. Could have closing remarks from Dr. Ibrahima Kane, and then Judge Kioko.
Well, the question is what to say after all this plea made by my predecessor. You know, for me, the only thing that I want to say is that without a leadership, we won't get anywhere. But without also the participation of the people, there is nothing tangible that can be done for Africa. So we need that leadership, and that leadership comes from our states. It's not coming from the AU. Even the leadership of the AU is elected by member states. So the leadership start in our countries, and for that, it's African citizen that needs to create that leadership. If that leadership is done, we'll there. And I personally believe in my continent. I personally believe that my continent one day will get there. Is it going to be done on my lifetime? I don't know, but we need to fight. All of us need to fight to make sure that during our lifetime, we do things that leads to that end. And that's why, you know, Ben Kioko has done his bid. He supported us. Now we are supporting Hajer. We are supporting Dondia. We are supporting your generation. We are supporting the generation of Apollin. That's how we can continue to do the work. We need to believe in ourselves, in our capacity, in the possibility that we can reach there, and to give us also the means that will lead us to that. We have it and we will do it, inshallah. Thank you.
Thank you. Thank you so much. That's quite hopeful, Dr. Kane. Judge, please.
I'm also an optimist, and I also believe that the continent will get there someday. I don't know when, but I think it's important to underline one point that was made by Ibrahima Kane, which is about leadership. He mentioned that in those days when Gaddafi was leading the push for deeper unity, there were other leaders who supported the process. And he mentioned Meles Zenawi, President Wade of Senegal, Bouteflika of Algeria, and Obasanjo of Nigeria. And I think, honestly, without those leaders, the majority of the other leaders would have said, we remain with the AU, with the OAU. So it's because of the leaders that's why the change came. And I think the Constitutive Act and the AU has honestly brought in some change that was not possible under the OAU. But that leadership, in my view, doesn't seem to be there right now on the continent at the level of our nations. And it's also very important that you have that leadership at the AU Commission. I recall that when President Konare, who had been president of Mali, became the chairperson, he's the one who came up with this idea of a strategic plan. He says, look, the only way we can get member states to agree that the AU can do something, the AU Commission should be given some powers, is to come up with a strategic plan. And they brought on African experts and they came up with a strategic plan. They approved everything. Then we went to the budget, and the budget was 600 million. And I remember him saying, these member states are going to say that they like my plan, but they don't like the budget, and are mad to think that they can give 600 million from 43 million. And indeed, they say that. But in the end, it moved from 43 million to 260 million. And right now, I think it's about 600 million, 600 something million. Now, and then the same Konare is the one who said, look, this building across where the OAU headquarters used to be, it was a high security prison. I'm going to talk to the Prime Minister of Ethiopia, and I'll go to China, and I'm going to tell the President of China that every time a summit is held anywhere on the continent, you go and build a conference center for the OAU summit, and it is not used again for 20 years. So if you want to help Africa, build one here. And we are going to build it in this prison, and I'm going to get Meles Zenawi, Prime Minister, to agree to it, which he did. And eventually the conference was built as a gift from China to the African Union. So the issue of leadership at all levels is very, very important. And that is also why you find that we are talking about non-implementation of decisions, non-implementation of treaties, is lack of political will. If the leaders were really committed to deeper unity and integration of the continent, it can happen or start happening. But without that commitment, that vision is going to take longer than sooner. Thank you.
Thank you, Judge. Going to Don Dea, who's the CEO of PALU, which is who are our collaborators, please.
Thank you very much, Elvis. And actually, thank you very much to the entire Kabarak Law team. You're a great, great partner to work with on a range of things, ranging from East Africa to the continent. We really like your energy, your comprehensive work, your discipline, and your foresight. This is one partnership that we really, really like, and we challenge many other academic institutions and think tanks across the continent to do the same, to emulate your style. I would also like to thank our speakers for today, my sister, Professor Hajer Gueldich, my big brother, Judge Ben Kioko, my other big brother, Ibrahima Kane, and my good friend, Apollin Zouapet. I think today we have had a good mix of insiders, both present insiders and former insiders, as well as outsiders. and as well as people I would describe as outside insiders, like Ibrahima. You can't really say totally he's been an outsider over the last 30, 35, 40 years. And I think this has kicked us off well. We have gone through the evolution of the continental organization from the roads from Casablanca and Monrovia to Addis Ababa and what I call the Compromise of May 1963. We've gone through the journeys from 1963 to the transformative moment of 2000 and the transformation from the OE to the AU. And we've also gone through the journeys from the 2000 moment to date. And I like that we have been bold enough to confront some of the contemporary challenges and dilemmas, especially the remarks made by Hajer and by Ibrahima. So just to remind you that this is the first of two webinars. Webinar 1 today was on the drafting history, the legal philosophy, and the broad objectives. And we will have webinar 2 this time next week, Thursday, 14th August, which will focus on the successes, the challenges, the future prospects, and the AU reform. And I really like that a lot of the presenters have still spoken about hope and the need to work together. They need to stop and reflect, but retool, re-energize, and work together. We need to really expand drastically amongst African individuals and African institutions their knowledge of Africa, their knowledge of the international organizational infrastructure in Africa. We need to have many more individuals and institutions openly identifying as Pan-Africanists and espousing Pan-African values, goals, targets, making demands and forcing developments. So this is just a start, and see you this time next week. And thanks once again to our Kabarak colleagues.
Thank you, Don there. So thank you so much for everyone who's attended. Thank you once again to the panelists. And I'd like to just close with a reminder once again that we are happy to remind you that Kenya has a candidate for the elections to the International Court of Justice in November 2026. And she's our close friend, Professor Phoebe Okoa. We are honored to support and contribute to her candidacy. So I'd like to once again thank you each and every one of us who's joined in, and please feel free to register in advance for the next week's webinar. Thank you. You can leave at our pleasure.
Bye-bye.